Thank you very much, everybody. I'd just like to introduce you to our Refugee Week event. That's the first of one of our 3 events for this year. This is the session on inadmissible asylum claims in light of the government's Rwanda policy, Nationality and Borders Act, and the illegal migration bill. I just wanted to welcome you all to Garden Court, those of you in person, and there's so far I think 115 people online. I hope you can all hear. If you can't, please put a message into the chat. It's a really important Refugee Week. I think as far as I can see, it's been going since 2009. And one of the early inspirations was to celebrate the contributions of refugees to the UK. And one of the early events was called Simple Acts. What one simple thing can you do to encourage people to make a change in the way that refugees are perceived in the UK? And although they wanted people to take big actions, I would say any action, big or small, to change that perception is hugely important. And I hope that will inspire us all for why we're all here. I do just have to mention, we're having those people who are here in person, there's some refreshments afterwards, and apologies for those in person who are hot at home who haven't got a chance to access those refreshments. Our event is being live streamed and the recording will be uploaded onto YouTube. And that link will be sent to everyone attending. Safety announcement, I should have to say that if the fire bell rings, please walk down the main staircase and the way you came in and across to Lincoln's Inn Fields. Everything else about location and facilities, I think you'll be able to work that out. So what we're going to cover in this session, as we said, was the implications of inadmissible asylum claims as determined by the government in the context of the Rwanda policy. And I'm absolutely delighted that we've got such a erudite and important panel this evening to talk about that, because everybody here was involved in the case which is currently in the Court of Appeal, judgment pending. And that's my colleagues Adrian, Isaac, Ricca-Richardson and Alison Pickup from Asylum Aid, who is joining us online. So thank you very much to them for joining. I just wanted to say, before I introduce their sessions, I just wanted to say a little bit about how the litigation has come into being and why we are, in fact, in the situation that we're in. So the Nationality and Borders Act 2022, I think received royal assent at the end of April 2022. And then very shortly afterwards, the government announced their migration and economic development partnership with Rwanda. And early May 2022, I think it was the 9th of November, they gave out the first notices of intent of liability for persons for removal to Rwanda based on their method of arrival, i.e. specifically irregular and arrival by small boats. And that led to the certification of various people's claims. I'm going to hear more about the process, about what happened in the sort of individual cases and access to justice, particularly from Alison and Isaac. But importantly, what that case started out with was a series of court hearings. I think I've counted about 10, but I may be wrong. In the initial interim relief hearing, to try to stop the removal of the initial cohort who were going to be put on a plane on the 14th of June 2022. That initial interim relief was refused by the single judge. It was appealed to the Court of Appeal. It was refused by the Court of Appeal. And a Rule 39 injunction was granted by the Strasbourg Court in respect of the one client, NSK, and then a following further 4 clients, or claimants, I should say, and 2 were refused on the basis that they hadn't exhausted domestic remedies, and those 2 were obtained interim relief from the Court of Appeal itself. This all happened on the same night, on the 14th of June, a very frenzied night of legal activity. And I think the last injunction was granted about 10 o'clock when the flight was due to leave at 10:30. So we then had a permission hearing and various case management hearings. There was a PII hearing over the summer, where the government then were directed to release the material that they had concealed from the claimants and from the court, more importantly. There was a divisional court hearing in early September that lasted 4 days. and then the judgment was handed down in just before the end of the term in December, and then a remedies hearing took place at the end of January 2023 this year. I mean, as you will know, many of you, that almost all, but not quite all, of the individual decisions were quashed, but the policy on the basis of procedural unfairness and failure to take account of material considerations. But the policy in general terms was held to be lawful. The court held there was no breach of Article 31 of the Refugee Convention. Ultimately, permission to appeal, there was then a permission hearing following the grant of permission on the papers to some people on some grounds and not others. And then there was a permission hearing. And finally, in fact, the permission was granted on all of the major grounds that had been sought. We then had a Court of Appeal hearing, which was at the end of April. Again, that lasted, I think, 4 days. And we are waiting for judgment, and we anticipate it to be, when I say soon, my estimate is any time before the end of this court term, which is, I think, ends on the 1st of August. So I would say my personal view is in the next sort of 6 weeks or so. But I may be entirely wrong, so I'm afraid you can't put me store on that. There were 17 grounds of appeal, I think I'm right in saying, so I won't tell you every single one of those, but that was distilled into the primary ground, which is Rwanda safe? Is it a safe third country to send people to, particularly people who've had no connection with that country? That was supported in evidence and in submissions by UNHCR, in particular in relation to factors about their understanding of the treatment of asylum seekers in Rwanda, based on their experience of the Israel-Rwanda agreement from 2016, the Rwandan government's interpretation of the Refugee Convention, and the risk of onward and indirect refoulement. And so that was the primary ground that took up most of the time of the court. They then also looked at the issue of retained EU law, the lawfulness of the policy, and then, and importantly, and Alison will speak to this, on how asylum seekers who have those decisions made in the UK to certify their claims under the inadmissibility rules, how they can get access to justice or have a fair procedure on that issue to be determined. And that's going to be one of the major issues, we think, going forwards, whatever the judgment says. But just reminding ourselves that those inadmissibility rules were what the case was proceeded under. That wasn't even the statutory provisions that had been brought into force by the 2022 Act. And so that is really where there'll be a potential, at least one more battleground, but arguably whatever's said in the judgment. So and the other final thing I'd like to just say about the Nationality and Borders Act before I turn to our panel is just that it's quite astonishing that most recently, I think on the 8th of June this year, the government decided that their flagship, I thought it was a flagship policy, I think they thought it was a flagship policy, of saying that distinguishing between Group 1 and Group 2 refugees, between method of arrival that led to differential status, access to family reunion and settlement, was going to be just abandoned overnight. It's good news on the one hand, because it means that we're kind of back to an earlier position than those very harsh provisions, but bad news in the sense that the government's position was, well, don't worry, because we're going to resolve all of those problems, in inverted commas, through the illegal migration bill, about which we're going to hear more from Adrian. So we're obviously in a state of legal flux on a number of reasons or a number of bases, and we're going to hear about now. But that's just what I have to say in the sort of opening and introductory remarks, and bearing in mind that people do have the opportunity to ask questions at the end, and I really hope that you will take the opportunity to do that. So without more ado, I'll turn first of all to my colleague Isaac Ricca-Richardson, who's barrister at Garden Court Chambers, who, as you know, is working on immigration and public law cases and was one of the counsel in my team on Rwanda. So thank you very much, Adrian. Isaac.
So, hi everybody. As Sonali said, my name is Isaac.
before you have the pleasure of hearing from the other panellists who Sonali rightly referred to as erudite and important, I'm going to talk to you for a little bit first about the topic of the legal regime regulating inadmissibility decisions. And when I say the regime, I mean both pre and post the 2022 Act. The reason I'm going to talk about both is that although the Act's been enforced now for almost a year, there are at least a cohort of people who made asylum claims before the 28th of June 2022 who are in limbo, and so they'll still be determined under the old regime. So it's important to be aware of both of those, depending on when your client or the claimant lodged their claim. So the first thing to say is when I talk about inadmissibility, I'm sure all of you know this, but I'm referring to third country cases. So that's where the Secretary of State says that an asylum claim should have been made in another safe third country rather than in the UK. I'm going to address you on each of the things in this contents page. So the first thing is the legal position for claims made before the 28th of June 2022. So that's set out in the immigration rules and also in the 2004 Act. The second thing is claims made thereafter, and I'll talk to you about the legal position there. The third thing is the Secretary of State's actual policy, which sets out the circumstances in which she's likely to take removal action for Rwanda. The fourth thing is briefly I'll talk about the impact of the Rwanda litigation on inadmissibility going forward, although as Sonali said, that is obviously ongoing. And then fifth, I'll just give you a few things that I think it's important to consider if you're trying to avoid an inadmissibility decision or trying to challenge it after it's made. So the first legal question for the pre-28th of June 2022 position is who out of the individuals who claimed asylum might be eligible for inadmissibility action. And the rules say that a claim may be treated as inadmissible if they have a certain connection with a safe third country. So the categories in the first two bullet points, they're fairly self-explanatory. They basically relate to positions where people already have protection, either formal refugee protection or some other protection against refoulement. The third category is a little bit more contentious, and that's where you might have more cases in casework, to be honest, and it's also where there's a bit more room for argument. And those are cases where somebody doesn't have formal protection, but it's deemed that they could enjoy it because they have a sufficient connection. And there are three ways that can be, as you see on the screen. Because they've made a protection application already, because they could have done so but failed to do so, and there aren't exceptional circumstances as to why they didn't, or because they have a connection that makes it reasonable for them to go there. And in the cohort of cases in 2022, the Secretary of State normally ran the second and third of those together. So she'd say, you were there, and if you weren't, you have a connection, that kind of thing. So the second question is, for somebody who is eligible for inadmissibility action and a decision is taken, what is the consequences of that for them? So essentially, these can be stated shortly. That the Secretary of State is then under an obligation, not a discretion, an obligation to try and remove them, either to the country to which they have a connection or to any other safe third country. In practice, at the moment, that means Rwanda alone, because there aren't any other countries with which we have any agreements. The only circumstance in which that obligation of the Secretary of State no longer exists is if two conditions are met, or one of two conditions. The first is where removal is not likely within a reasonable time, and we'll come back to what that means in a moment. And the second is if the Secretary of State considers that removal would be inappropriate. Again, that's a non-defined term, but we can come back to what that might mean in a second. Third question, really, which all of this begs, is what a safe third country actually means. It's defined in paragraph 345B of the rules. You can see the four conditions there. They all have to be satisfied in order for a country to be safe. I'm not going to read them out to you, but there's just two things I think it's important to bear in mind in this context. The first one is that in order to enact removal action to Rwanda, the Secretary of State has to be satisfied not only that the country that there's a connection to is safe, but also that Rwanda is. And they might obviously be different given the different conditions in both countries. And the second thing to say is that these conditions effectively map onto Refugee Convention protection. So it's not conditions in general. You can't argue that it would be a breach of Article 3 in general to send them there because of their health or anything like that. You have to show effectively that if it is anything to do with conditions, the mistreatment will be on a convention reason. And the other conditions relate to refoulement and things like that. So the next question is the relevance of the 2004 Act. And in the case of AAA, so the Divisional Court judgment, they made clear that this was integral to inadmissibility. And the reason for that is that certification under the 2004 Act, specifically under Schedule 3, is the only way prior to the 2022 Act to disapply what is ordinarily a prohibition on removing people that have asylum claims. So unless you certify under this Act, you can't remove someone until that claim is determined. The test for certification is set out in paragraph 17, and you can see it on screen there. It's effectively the same as the test under the rules. There's unlikely to be much argument about that beyond what you're already arguing in terms of the rules. Now, as well as allowing removal, the other thing to bear in mind about certification is that it prevents a claimant from bringing a human rights appeal whilst they're in country. So for pre-2022 Act claims, you will still have an out-of-country appeal right, but you can't bring it in country unless you challenge the separate human rights certificate. So that's, in my view, everything about the pre-2022 Act position. But then you need to consider what has changed and what's the same under the new Act. So I think it's easiest to start with what's the same. And as they said as the Divisional Court said in the Rwanda litigation, the position is largely similar. What I mean by that is that it still depends on connection to a safe third state. The definition of a safe third state is substantively the same as what it was before, so it's still those same conditions. And the effects of an inadmissibility decision on an individual claimant are the same in terms of not being able to have a decision made, not being able to appeal. But while the overall framework remains the same, there are a number of key differences, 5 in total as far as I can tell. So the first is that whereas previously inadmissible asylum claims were substantively considered if removal was considered inappropriate, now you must show that there are exceptional circumstances as to why your claim should be considered. So this applies where there is a safe third country, all of the test is met, you can still show that there are exceptional circumstances why they shouldn't be removed. The second difference is that where an asylum claimant has been present in a safe third country, to avoid an inadmissibility decision, that claimant must now show that it would not have been reasonable for them to make a claim there. So that's different to the previous permission where you had to show that there are exceptional circumstances. In terms of those changes of language, it's unclear how much of a substantive difference they'll make, but be prepared for arguments that they are different. And in terms of the second one, so about it being reasonable to make a claim in a third country, it's actually arguable, I think, that that test is more generous to claimants because showing it's unreasonable to make a claim seems to be easier than showing that there were exceptional circumstances. Third difference to the position under the rule is that the Secretary of State no longer needs to issue a separate certificate under Schedule 3 of the 2004 Act. As you can see on screen, that's because Schedule 4 of the 2022 Act has revised the 2002 Act so that automatically, if you're trying to remove to a safe third country, you can do so without needing to determine an asylum claim. Fourth difference is that there is now no out-of-country appeal right at all in terms of a human rights claim that's certified as clearly unfounded. So whereas the claimants who made a human rights claim before 28th of June, if they were sent to Rwanda, hypothetically, had they been, they could have run an appeal from outside the UK. Now, if they're sent and they don't challenge the human rights certification by JR, there'll be no remedy at all. So once they're out of the jurisdiction, that's the end of the matter in terms of the human rights claim. And then the fifth point that I've got on there, it's not really a difference, it's more just something to note, which is that while the purpose of the 2022 Act was to put in the inadmissibility regime on a statutory footing, the Secretary of State chose not to legislate the rule that a claim would be admitted for consideration in the UK if removal is unlikely in a reasonable time. At the moment, that rule is still in Rule 345D of the immigration rules, and it's in the Secretary of State's policy, which means that she says that if it can't be decided in, for example, 6 months, then it will be admitted in the UK, but that's only in the rules, so it could be changed at any time. So those are, in my view, the main points to be aware of about the legal framework for inadmissibility. They include the circumstances in which it's legally permissible and the effect that it has on claimants. The next important issue is what the Home Office's policy on removal to Rwanda actually is, so when they're likely to take action. And you'll find this in their inadmissibility guidance, which makes clear that the Secretary of State will only consider inadmissibility where two conditions are met. They're very well known, I'm sure, to everybody here, but effectively the journey has to be described as dangerous, primarily directed at boats, but it could include lorries or anything like that. And then the claim must be made on or after the 1st of January 2022. If those conditions are met, there are very few groups of claimants who are expressly excluded from third country inadmissibility. In fact, the only individuals or groups of individuals expressly exempted in the policy are families with children under 18, unaccompanied minors, and EU nationals, although EU nationals have a separate policy and legislative framework around inadmissibility. One thing to note, though, is that the policy does say that if the appellant makes detailed representations about inadmissibility, it may be necessary to engage in more detailed consideration. That is presumably a nod to the fact that you have to consider each individual case on its merits, although in the Court of Appeal, one of our grounds of appeal was that that guidance doesn't properly reflect that obligation, so it doesn't go far enough to make clear to caseworkers that this shouldn't be an automatic process by rote, and it's something that needs to be considered on the facts. And then the last bullet point on the slide is about what constitutes a reasonable time. In short, the guidance says it's often 6 months, but it might be more or less depending on the circumstances. And I think that Alison is going to talk about that in more detail, so I'll leave that to her and then we'll take any questions afterwards. So the penultimate thing that I want to talk about is the effect of the Rwandan case. Now, Sonali's talked about this in some detail already, so I won't go through everything. But to start with what was unhelpful about the judgment, the Divisional Court effectively held that in general the policy was lawful. In other words, there is nothing wrong in principle with sending asylum seekers to Rwanda to have their claims determined there. In reaching that conclusion, the Divisional Court rejected each of the so-called generic arguments that were made by the claimants. So you can see some of those on the slides. Effectively, they said the Secretary of State had properly examined everything, therefore discharging the Ilias duty. That Rwanda's asylum system was sufficient to avoid a risk of refoulement in general, and that there was no general risk of Article 3 ECHR harm due to conditions. Now on that third bullet point, they accepted actually that there was evidence of human rights breaches generally, and indeed human rights breaches towards refugees in camps. But they said that there was no reason to presume that that would also affect migrants or refugees transferred under the UK scheme. So if you're wondering how exactly the Home Office reached that conclusion, the court reached that conclusion, a substantial amount of their reasoning came down to the assurances that were given by the Rwandan government. The court concluded that if those assurances were fulfilled, the system would work perfectly reasonably. The claimant's case was that there was no reason to assume those assurances would be fulfilled, essentially because there was a track record of not fulfilling assurances in previous agreements with Israel, because there was not really much in the way of monitoring, and also because of the strongly negative views of the UNHCR, which I'm sure everybody would have seen. But this was rejected by the court, who concluded that the Secretary of State was entitled to rely on those assurances, and that answered really, in the court's view, most of the concerns that have been raised by the claimants. So, I mean, that all sounds, I think, quite concerning from the point of view of asylum seekers already in the UK. The good news, as far as there is any, is that the court's judgment was not a permission to the Home Office to simply declare all asylum claims inadmissible and try to remove people to Rwanda. What they said is that in all cases, you have to consider the individual circumstances of the given claimant and determine whether on those facts removal action is appropriate. So there's still scope, absolutely, to argue that it shouldn't take place on your client's facts. And of course, as I say in the second bullet point, those conclusions that I've been through, made by the Divisional Court, are all under challenge at the moment, as Sonali has said. So it's unclear what the final outcome will be. And of course, there's the opportunity or possibility of a further appeal to the Supreme Court as well. So the last thing that I want to touch on, just very briefly, is some key things that it's maybe worth considering if you're a claimant or if you have clients who are claimants and may possibly be eligible for admissibility. So the first thing, as you can see on the screen, is, in my view, it's really, really important to make a strong human rights claim and make it as strong as possible. There are two reasons why I say that. The first is that, whereas, as I've said, the safe third country test under inadmissibility is limited to matters that are relevant to the Refugee Convention, the human rights claim is obviously far broader than that. So that's where you can bring in anything relating to human rights, so family life with anyone in the UK, any vulnerabilities that may raise a risk of breach of Article 3 or 8, so mental health, anything relevant to potential victims of trafficking or torture survivors or anything like that. So it's just much broader in scope is the first reason. And the second, which again I'm sure most people will be aware of, is that whilst the Secretary of State is also likely to certify any human rights claim, there's a much lower threshold for challenging that. So all you have to show is that a judge taking your claim at its highest could rationally allow the appeal. So that has to show that they would allow the appeal, just that they could. And that's obviously a pretty low threshold as challenges go, which means that that may well be the best option for your client to prevent removal, at least in the short term. The second thing I'd just say briefly is that in cases where a claimant has transited through a safe third country, it may be possible to argue that it was not reasonable for them to claim asylum. So in the Rwanda litigation, you can see at paragraph 236, and there are other examples they deal with the specific cases at the end. There were several cases where the decision was quashed because they failed to consider that properly. One example is where there was ill treatment by police, but there were other examples of state ill treatment. And another category of people who often did escape disability action in 2022 were people who were potential victims of trafficking. Obviously, you can argue then that it's not really reasonable to have claimed if they were coerced into that situation anyway. The third tip is to consider whether your client has exceptional circumstances that mean it would be inappropriate to remove them. So those are the two tests: exceptional circumstances now and then inappropriate before. And this is where you can get non-refugee convention related issues into a challenge against inadmissibility. It's 345D in the rules, and it means that you can argue, it is a safe third country in refugee convention terms, but my client has X, Y, Z vulnerabilities that mean it would not be appropriate to send them there. And there is some evidence that historically that may have worked, because in a lot of the 2022 decision letters, they referred to the fact that claimants who ended up in the process didn't meet the adults at risk criteria. One can take from that people who did meet that criteria may well have been funneled out of the process. The Home Office in the litigation said that was an operational rather than policy decision. I'm not entirely sure what that distinction means, but it was used to say that their policy wasn't unlawful because it didn't need to reflect that. But that doesn't change the fact that it's worth considering. If there's another round, it may be something that is able to get a client out. So if there's something that suggests vulnerability, that's definitely something that should be explored and put in reps. And then the very final tip I have is just to explore the relevance of political expression to your client and whether that's something that may be germane to them in Rwanda. Obviously, this will not arise for all asylum seekers, but if, for example, you have a client whose case is already about political dissent or similar, it may well do, and it's worth asking them. And there are 4 reasons why I think that's an area that is possibly most ripe for further exploration. As you can see, the first is that there is a real wealth of evidence about that, not just from the usual NGOs, but also from the Secretary of State's own disclosure. So Sonali referred to the PII public interest immunity application. The disclosure that came out of that was a senior FCDO officer who had extensive experience in the region, who basically said that anybody, including refugees who expressed any disagreement with the regime, would, he didn't even say could, he said would be mistreated or at risk of mistreatment. The second reason is that, unlike with other issues engaging Article 3, which the CPIN Country Policy and Information Note from the Home Office says there's no risk, in terms of political expression, they still say starting point is no risk, but they even admit that if you can show specific evidence as to why you may raise an opinion that would be adverse to the state, it could possibly open up a degree of risk. The third point is that unlike general conditions, which, as I said, aren't relevant to inadmissibility, any risk arising from political expression is, because political expression is, of course, a convention ground. And so any risk of harm arising from it has that required nexus to the Refugee Convention. And the fourth and final reason why I think this is something worth exploring with any claimant is that although the Divisional Court found that there was in general no risk arising from political expression, that was at least partly because of the fact that no claimant in that litigation had any evidence to suggest they would ever protest. So if there are another raft of people who are more aware of the situation in Rwanda from this litigation, they say that they would not tolerate it, that may well be a different position. And in my view, the court at least left open that possibility whilst not expressly approving it. So that, I think, is everything that I wanted to say to you today, and I will pass you back over to Snyder. Thank you.
Great, thank you very much. I'm going to take all the questions at the end, if I may. So I'm going to turn now directly to Alison Pickup, who is online, and is going to talk to us about Rwanda and the fairness of the procedure. Thank you, Alison.
Hi, everybody. Very sorry that I can't be there with you in person, and particularly sorry that I'm going to miss out on the drinks afterwards. But thank you to Garden Court for inviting me to speak today. I'm going to focus on procedural fairness within the inadmissibility process, both at this time last year when people were facing removal to Rwanda under the Rwanda plan. What's happened since then, since June 2022, what's happened to people who've been served notices of intent, and then I'm going to look very briefly at procedure under the Illegal Migration Bill before Adrian takes us in more detail to the bill. So I wanted to start with sort of nuts and bolts, really, about procedural fairness. I'm sure this is all very familiar to everybody, but I just think it's really important to remember that this is what is at heart here. This is common law principles of fairness that apply to everyone, including asylum seekers, under centuries-old jurisprudence, really. So I've taken this directly from our skeleton argument in the Court of Appeals. I've given credit to our counsel team. It's a fundamental principle of common law fairness, of the common law, that fairness very often requires those who may be adversely affected by decisions to have the opportunity to make representations in order to influence them in their favour. And of course, we know that the extent of that opportunity varies according to context, but it has to be an effective right, and therefore you have to be informed of the factors which weigh against you. And then secondly, I guess in terms of the importance of what's at stake, obviously the more significant the rights or interests at stake, the greater the opportunity that you have to be given to make representations. So decision-making powers which have enormous consequences for people require notice, an opportunity to be heard in advance of the decision being made, and an explicit disclosure of the substance of the matters on which the decision maker intends to proceed. And as I'm sure many of you will, the next part will be very familiar, that asylum and human rights decisions, which are literally a matter of life and death, are of such moment that only the highest standards of fairness will suffice. And what I want to try and show is that it's against those tests that the fairness of the procedures being used to decide who is inadmissible to our asylum process need to be considered. So in the context of the Rwanda plan, what are the decisions that actually lead to removal? And here Isaac's very clear and helpful introduction to the tests will allow me hopefully to take this quite quickly. So first of all, the Home Office has to take a decision that the individual is inadmissible under the relevant immigration rules and the 2022 Act. And as Isaac's just taken you to, that basically involves, in most cases, asking if they travelled through a third country, and if so, was that third country safe for them, and could or should they have sought asylum there under the 2022 Act? Was it reasonable for them to have done so? So there's the first two decisions the Secretary of State has to take. And then thirdly, under the Rwanda policy, was their journey to the UK a dangerous one, and did they arrive after the 1st of January 2022? That's perhaps more straightforward. Fourthly, is Rwanda safe for the individual? And as Isaac mentioned, because there's no statutory presumption of safety for Rwanda, that involves consideration of the risks of breach of the Refugee and Human Rights Conventions, including indirect refoulement to a country where their rights under those conventions would be breached, as well as the availability of protection for someone who is recognised as a refugee which should be at least equivalent to that required under the Refugee Convention. And then fifthly, human rights considerations in relation to Rwanda, so the human rights claim that Isaac mentioned. And if that's unsuccessful, then sixthly, the Secretary of State needs to decide whether to certify the claim as clearly unfounded. So those are the 6 decisions that lead up to removal, and in respect of which common law requirements and procedural fairness have to be met. So what happened in 2022 when the Rwanda plan first started to be implemented? Well, the starting point was people arriving in the UK, normally by a small boat or other dangerous means. They would then be detained, and generally speaking, at this point, that was what was happening, as many of you will know, and have a standard screening interview, which, yes, asked them questions about the route they travelled to the UK, but didn't tell them, usually at that stage, they might be considered for removal to Rwanda. And that interview was normally done within 2 or 3 days of arrival. They were then served with the pro forma notice of intent in English, indicating that the Home Office considered that they may be inadmissible, and if they were inadmissible, they may be removed to Rwanda. And they were also given a very brief information pack, which set out in very general terms the Home Office's view that Rwanda is a safe country which will treat them well as asylum seekers. That information pack was initially served only in English, although later on it was translated into some of the more common languages. Following service of the notice of intent, people were given a 7-day period for responding to that notice and basically making representations on all of those 6 decisions that I outlined on the previous slide. There was apparently the possibility of extension, but that possibility was not stated in the notice of intent itself, or indeed in any published policy. And in practice, it was rarely granted, or if granted, not granted for the full amount of time that was sought in order to deal with all the many issues that arose. There was no guarantee of access to legal advice before responding to a notice of intent. So unlike, for example, past fast-track schemes, such as the detained fast-track, where people were allocated a legal aid representative, the only provision here was reliance on the general detained duty advice scheme. So on people knowing about the DDA scheme, signing up for it, and getting an appointment. And those of you who know how the DDA scheme works will know that it's a 30-minute initial appointment, and any follow-up work won't happen on the same day. So that all finding out about legal advice, getting it, accessing it, giving instructions, receiving advice, gathering evidence, and making representations was all supposed to be done in 7 days from receiving a notice of intent, telling people who were detained and had just arrived in the country that they might be removed to Rwanda, a country which most of them had no connection with and many had never even heard of. Following that 7-day period, then all relevant decisions, all of those 6 decisions that I've just mentioned, could then be taken and be served together with removal directions, with only a 5 working day notice period before actual removal, minimum 5 days. In some cases it was longer, but the minimum in the policy and rules was 5 working days. So I think it will be readily apparent to those of you who work in this field without me needing to sort of go into the details, that 7 days was clearly too short to do all the things that you would need to do to respond and for people to have fairness. So Asylum 8 brought a judicial review challenge focused on the fairness of that procedure. We had 3 grounds, which basically amount to saying that the 7-day period, or 14 days, for those who are not in detention, with only minimal disclosure and no guarantee of effective access to legal advice, was plainly inadequate to enable the Home Office to gather the information they needed to make the decisions lawfully, to do the individualised assessment that was required under the 2004 Act, and to ensure procedural fairness in accordance with those common law standards prior to a decision being taken, and also to ensure effective access to legal advice and thus to the courts before removal took place in that 5 working day window. So that was our claim, and our claim was joined together with the claims brought by various individuals and some other NGOs, challenging the safety of Rwanda and other aspects of the decision, as Isaac's alluded to, and Sonali. They were joined together, they weren't actually heard together in the divisional court, but there's a single judgment dealing with all of our claims. The divisional court dismissed our challenge to the procedure on the basis, essentially, that I've set out here on this slide. So first of all, Divisional Court said that fairness doesn't require individuals to have an opportunity to make representations on whether Rwanda was generally safe or on any other matter apart from the facts specific to that individual. So your only right was to put forward anything in your individual circumstances that meant you shouldn't be removed from Rwanda, rather than making representations about the general assessment that the Home Office had made about the safety of Rwanda for asylum seekers and about how the Migration and Economic Development Partnership would work. And so as a consequence of that, the Divisional Court held that fairness didn't require individuals to have sight of or the opportunity to make representations on Secretary of State's provisional evaluation of matters relevant to their claim, or the information relied on to judge the safety of Rwanda. So it didn't matter that people hadn't been told why the Secretary of State thought Rwanda was safe beyond what was in the information pack. And thirdly, given the scope of that right, how limited that right to make representations was, people didn't need access to lawyers to make those representations, so that our concerns about the difficulties people would face in getting legal advice in the 7-day period didn't matter, because you didn't need access to lawyers in order to be able to make effectively make representations, and 7 days would be enough to make those representations. And finally, they held that because they dismissed our claim on procedural fairness prior to the decision, because they said the right to make representations was so limited, that they said took away the premise for our submissions on access to justice and fairness generally, and so they dismissed the whole of our claim as well as the arguments on procedural fairness made by the individuals. So we have appealed against that decision. Like all of the other appeals, our appeals were heard at the end of April, and as Sonali said, we're still waiting for judgment. We had 6 grounds of appeal, which we got permission from the Divisional Court on. Basically, that the Divisional Court was wrong on every point that they relied on to dismiss our claim. So they were wrong to hold the procedure wasn't systemically unfair, and in particular, that they didn't require the opportunity to make representations on general safety. They were wrong to say we didn't need access to lawyers, wrong to say that 7 days wasn't enough time to make representations, wrong to say that we don't need disclosure, and wrong to say that the access to justice argument falls away, and their analysis of the statutory scheme was flawed. So that's where we are. We're waiting for judgment from the Court of Appeal, as Sonali said. So turning then in terms to what's been happening since June 2022, as many of you will know, notices of intent specifying removal to Rwanda as a possible destination have continued to be served. The information pack, as I said, has now been translated into some languages, but the information that we've heard from partners and from colleagues and from clients is that it's not always being served with notice of intent anymore. The note verbal, which were the diplomatic promises that kind of underpin the memorandum of understanding on the plan, on the agreement with Rwanda, have now been published, and links to those and to the Home Office's country policy information that should be provided to people with the notice of intent. So at least in principle, the Home Office should now be providing more information about the basis for their assessment that Rwanda is safe. From what we are aware of at Asylum Aid, since around the end of August last year, the notices are mainly being served on people in the community, and so they therefore have 14 days to respond rather than the 7 days given to people in detention. But they're being sent by post to people in often hotels, so there's often a delay in them actually reaching the person, or they may be sent to an address where the person is no longer accommodated. There's a bit of a lack of clarity about whether the time for responding runs from the date of service or from the date that the notice was issued. And there's still no published policy or information in the notice about extensions of time. And obviously, most concerningly, the legal aid crisis means that for people served with these notices in hotels, access to legal advice in 14 days is next to impossible. We're also seeing that people who've been served with those notices of intent, including people who were served them in detention in that first cohort, are often, or perhaps generally, or perhaps always, I'm not sure and would be interested to hear, admitted to the asylum procedure, despite the fact that it's been over a year and there's no real prospect of removal to Rwanda in the near future. And even where they're from one of the high grant countries that are subject to the streamlined asylum procedure, so where if they were admitted, they'd be very likely to be granted and to be granted quickly, they're being left in this limbo. So that to me raises real questions. Isaac mentioned paragraph 345D of the immigration rules, which at the moment still provides that where Secretary of State believes that removal to a safe third country within a reasonable period of time is unlikely, people should be admitted to the UK asylum system, even if they're inadmissible. That's still there. The policy guidance still says that the inadmissibility process shouldn't create a lengthy limbo position. And if it's not possible to make an inadmissibility decision or effect removal following that decision within a reasonable period, inadmissibility action should be discontinued. It also says, as Isaac mentioned, that 6 months is the general guideline for what's a reasonable amount of time, although it says that sometimes that will be shorter and sometimes it'll be longer. And I think probably the Home Office would say that the last point on that slide, that outstanding legal proceedings, i.e. the Rwanda litigation, is what makes this very long period of limbo that people have been left in a reasonable one. So leaving then the situation under the pre and post 22 Act, and just looking briefly before I hand over at the illegal migration bill and what we know about what's planned in that bill and the procedure there. And I think just you'll see immediately the parallels with the concerns about the procedure under the Rwanda plan. So as you all know, basically protection claims and human rights claims will be automatically inadmissible if the 4 criteria which lead to the duty to remove apply. And that's basically that you arrived in the UK without leave. I'm simplifying and summarising on or after the 7th of March and didn't come directly to the UK from a country where your life or liberty was threatened for a refugee convention reason. You'll be automatically inadmissible in those situations. It appears from the structure of the bill that there'll be an initial decision that you're subject to that duty to remove, so a decision that those 4 criteria apply. It's unclear at the moment what opportunity individual asylum seekers will have to put forward evidence or representations, for example, on the question of whether they came directly before that decision is made. But my assumption is it will, like under the Rwanda plan, be based on a screening interview. The decision to remove that's then made will include notice of the country of intended removal, and that triggers the possibility of making a suspensive claim, either a factual suspensive claim or a serious harm suspensive claim in the case of removal to a third country. And it also is possible, still intended to be possible, to make a human rights claim or bring a judicial review in relation to the decision to remove, but those will not be suspensive of removal. So the suspensive claims procedure gives you an 8-day claim period to make a suspensive claim, beginning with the day the notice of removal is served. So very similar, in fact, exactly the same as the 7-day period under the Rwanda plan, because the 8-day claim period includes the day that you're served with the decision. That can be extended by the Secretary of State before the end of the decision period, and they can also accept a late suspensive claim. The Secretary of State then has 4 days to make a decision, but again, she can extend that period. And then there's a right of appeal to the upper tribunal against a decision not to accept a suspensive claim, which you have to file within 7 working days, and that gets considered by the upper tribunal within 23 working days. So all of that process, you making your suspensive claim, Secretary of State deciding it, and then the upper tribunal considering your appeal against it, is intended to be dealt with in about 42 days, so about 6 weeks. But you can't be removed during that period, so that is all suspensive. And then you have your non-suspensive claims where you can be removed. It's unclear how you make a human rights claim in those circumstances or how it's going to be decided, but there isn't a right of appeal against the refusal of your human rights claim itself. Your only remedy will be judicial review, presumably after you've been removed from the UK to the third country. It's also available in relation to the decision to remove, which again is not intended to be suspensive. So I think there are real parallels between what seems to be intended in terms of the procedure under the illegal migration bill and the procedure that we're challenging in the Rwanda litigation. And real concerns about the fairness of that procedure, given the importance of what's at stake and whether it can possibly comply with those requirements of the common law. Yeah, I'll leave it there.
Thank you very much, Alison. Thank you. So if that wasn't quite depressing enough for everybody, I'm going to ask Adrian now to talk, to pick up that thread that Alison left us with, in relation to the provisions of the illegal migration bill, which are currently in the report stage, I think is right, in the House of Lords. And again, don't forget we have questions and answers for Adrian's presentation. Thank you.
Thank you very much. So inadmissible asylum claims, it's Refugee Week, so the idea is that people turn up on the territory and they get some protection under international treaty obligations that the UK has entered into, the Refugee Convention and the Human Rights Convention. It appears to be the mission of the current government to try and stop there being another Refugee Week through the process of inadmissible asylum claims. That's where we're at. They leave no stone unturned with this idea that if you arrive here and claim protection, you claim asylum, then you will be in the situation that you won't have your claim determined, and therefore you won't have a decision, and therefore you won't have a right of appeal. And what we have seen is the gradual growth of this idea of there being inadmissible asylum claims. As Isaac and Alison have already mentioned, the Rwanda scheme was brought under the existing immigration rules, the existing legal framework that we had before the Nationality and Borders Act. There was then amendments made to the inadmissibility regime under that act, and now we have a second set of amendments under the illegal migration bill. And you would think, what's left? You might think, if you're not going to determine an asylum claim, how many more ways can you skin this particular cat? But they have gone the extra mile, and we have two different sorts of ways in which inadmissibility now works. And what I want to do when we look at the changes that we're going to discuss in the illegal migration bill is to really put two pockets on either side of what's going on. In the first pocket, we put the amendments to the existing inadmissibility regime. So this is for people who won't be falling under the duty to remove. It's coming in under the illegal migration bill for those who've made the journey to the UK and arrived here on an irregular basis. In the second pocket, we put inadmissibility as it's used under the illegal migration bill. And so that's going to be for the purposes of removing people without determining their claims when they fulfill the four conditions of Clause 2 of the illegal migration bill. So we're going to look, and the reason we need to go to the amendments to the already existing process first is that we're going to understand that in its own terms for people who don't fall within the illegal migration bill's duty to remove. But we also need to understand how it works, because various bits of it are then cross-referenced and deployed for the purposes of what's going on with the duty to remove under the illegal migration bill. So I'm not going to pretend it's not complicated, but there is a way through it. And say, we can see here that first of all in the bill we have clause 57, which deals with amendments made to what is part 4A of the Nationality and Immigration and Asylum Act, which is itself an innovation introduced under last year's bill. So this is the existing inadmissible asylum claims regime. And as we've already noted, well, in respect initially of asylum claims, so not human rights claims by EU nationals, the Secretary of State must declare a claim inadmissible unless she considers there are exceptional circumstances. Exceptional circumstances include where there's a derogation under Article 15 of the ECHR from an obligation of the sort that we saw after 9/11 with the Anti-Terrorism, Crime and Security Act allowing indefinite detention, or an equivalent disciplinary procedure. And it's quite amazing how under the Treaty on European Union, we may have left the European Union, but in this respect, the UK likes to borrow from the Treaty on European Union. And if the EU itself is taking steps under its Treaty on European Union to discipline a member state that's derogating effectively from fundamental rights protection in the EU legal order, that too can constitute exceptional circumstances. So a claim generally from an asylum claim from an EU national must be declared inadmissible, therefore it's not determined and therefore there's no right of appeal. That's the existing regime. So the illegal migration bill goes further, it changes that. It covers human rights now as well as asylum claims, so human rights claims as well as asylum claims, and it extends not only to the nationals of EU states, but also to nationals of states specified in a new section 80AA, which is going to be inserted into the 2002 Act. And so it's going to cover EU states, EEA states, so that's Norway, Iceland, Liechtenstein, and so on. And then most notoriously Albania, which is of course a country producing a large number of people coming here seeking protection whose claims are successful. and who are receiving protection either on initial grant or on appeal. And so both asylum claims and human rights claims from people from those countries will not be considered. They will not be determined, and there will be no right of appeal to the first tier tribunal. And then there's a second part to this, that there's this list. Obviously, hitherto, it's always been EU states. You know where you stand with them because the state is either a member of the EU or it's not. But now there's a list. There's a list, and obviously Albania's on it, which is the outlier. And the Secretary of State may add to the list, but only if satisfied that in general, that's a key term, there's no serious risk of persecution of nationals of that state, and that removal to that state of its nationals will not in general contravene human rights obligations. So we've broadened the class of states involved, we've added human rights claims which must be declared inadmissible, and that list itself can be subject to further amendments. In deciding whether or not to add to the list, the Secretary of State must have regard to all the circumstances, including its laws, and critically, for our purposes, how they are applied. And then must have regard to information from any appropriate sources, including, again, EU states, and then regulations to add or remove a country from the list are to be made by a statutory instrument. And then there's a further point to this, is that if a state is going to be added to the list, it must be added by the affirmative resolution procedure and approved by a resolution of each House of Parliament. But if a state's going to be removed, there's a sort of quickie procedure to annul, to create the statutory instrument to remove a state, subject to any annulment there. So there's different ways. There's a tiny amount of extra procedural safeguard if you're going to add a state to the list. Happily, nothing is ever original in statutory drafting these days. We've had designated safe third country lists before, and there's a bit of case law around when you can add a state to the list. And so I've just put it on the slide, so you can see a couple of classic examples, Javid and Brown, those two cases. Worth bearing in mind, worth a reread. Obviously, they are of a certain vintage, but the learning in that as to when you can judicially review the addition of a state. Very few of us in this room are likely to judicially review the removal of a state from this list, but on the adding of a state, you can see there's some old learning that we could reread with profit. Note, so we're still dealing with the regime, the amendments made to the existing regime for people that don't fall within the duty to remove under the Illegal Migration Bill. And you can see that there's still also the procedure in respect of certifying refugee convention claims in Schedule 3 of the 2004 Act, which was part and parcel of what happened in the Rwanda litigation. So bear in mind, there are some things which are changing in Part 4A of the 2002 Act, and there are some things which were already modified for the certification for refugee convention purposes by the Nationality and Borders Act, which still exist under the 2004 Act. So don't forget about them. And then, of course, Isaac's already touched on Section 80B concerning asylum claims by persons with a connection to a safe third country. So we're still inside the regime as it exists for the purposes of people who don't fall within the Illegal Migration Bill's duty to remove. And so we've touched on that, and just for reasons of time, I'm going to leave it on the slide, but the inadmissibility regime, which we see here in sections 80B to 80C, which was the replacement for paragraphs 345 capital A to 345 capital D of the immigration rules, you can see there that it's set out as it exists. And so bear in mind, for anybody who's, if you like, non-illegal migration bill, for that cohort of people, you will find that they are still subject to this regime, which we've looked at already in the presentation. So I'll not touch on those things. I've set them out on the slides so you can see them. And of course, connection to a third state, one of the five conditions has to apply. So that's the regime. The main point is Section 80B and Section 80C don't change. But as we looked at the outset, in terms of Albania being added for the purposes of determining an Albanian human rights claim and an Albanian refugee claim will be declared inadmissible and therefore will not lead to a determination of that person's protection claim. And so that's the important innovation. But in and among that, in Section 80A, of course, is also the fact that EU citizens will lose determination of their human rights claims, which from a family reunion perspective, there's maybe a bit of collateral damage and not the main fight in a sense, but because of refugee claims from people coming from outside of Europe is often the focus of our concern. But it's nonetheless quite a surprising result of extending inadmissible claims to human rights claims and scheduling EU citizens on that list. Something potentially of great interest to the European Commission, to the EU delegation in London, to the Independent Monitoring Authority, potentially a whole range of bodies may find that of concern. And so it's something to bear in mind. So now we turn to the second way in which inadmissibility is being used now under the Illegal Migration Bill. We've dealt with the Albanian situation, if you like, in Section 80A and Section 80AA as modified. And now we're going to look at what Clause 2 does just very briefly. Is duty to remove on the Secretary of State, where Condition 1 has 4 permutations, but the main ones for our purposes are where a person requiring leave enters without it, or where a person arrived in the UK without required entry clearance. You entered or arrived on or after the 7th of March this year when the policy was announced. You did not come directly to the UK, noting that the Illegal Migration Bill has its own specific definition of what coming directly actually means from a country where effectively your life or liberty are threatened for refugee convention purposes and you require leave to enter or remain. So these are the 4 conditions you may have, as you know, we're not here today across the whole of the Illegal Migration Bill, but it may lead to a suspensive appeal if one of those 4 conditions, you challenge the fact that you don't satisfy those 4 conditions. And then the duty, certain claims are disregarded under Clause 4 of the bill. The duty to remove a person applies regardless of whether the person makes a protection claim, a human rights claim, is a victim of slavery or human trafficking, or makes an application for judicial review in relation to their removal from the UK. And that, of course, dovetails with Clause 52, which limits or the effect of interim remedies, judicial review interim remedies. But we're not here again across the whole course of the bill, but just to note that point in passing. And so if a person meets one of the 4 conditions that we just looked at there on that particular slide, then and you make a protection claim, that person, or a certain sort of human rights claim, and as we'll come on to look at that, the Secretary of State must declare that claim inadmissible. You satisfy the 4 conditions. Most stereotypically, you've come across, you've arrived in the UK on a small vessel travelling from France, and then you make a human rights claim, you make a protection claim. The Secretary of State must declare that inadmissible. But note here, just in passing, that the human rights claim, which must be declared inadmissible, is in relation to your claim for protection from the country of which you're a national citizen, or the country which issued you with a passport or other form of travel document. So it's about human rights claims in relation to your own country, effectively. Those must be declared inadmissible, where those 4 conditions are satisfied in Clause 2. And so the claim's not considered, there's no right of appeal. And then bear in mind that this position in respect of a human rights claim in respect of removal to a third country is slightly different. So your claim, your human rights claim in relation to your own country is inadmissible, but if it's about in relation to a third country, there will be a decision taken on the claim. It's just that you won't get a right of appeal to the first tier tribunal, and so your remedy will be judicial review. So, of course, the whole point about having the duty to remove imposed on the Secretary of State is to enable removal. And so if this was another seminar on remedies, we would be saying, well, of course, there are no interim remedies which can arrest removal, and that Rule 39 indications from the Court of Human Rights are not to be considered under Clause 53. So that's something to note in passing. But the inadmissibility of your protection claim against your home country and your human rights claim against your home country is in order to enable removal, which is provided for under Clause 5, to one of these territories in outline, but we'll come on to see how in practice the countries of destination are narrowed. The duty is on the Secretary of State here to make arrangements as soon as reasonably practicable, and there are certain provisions, and I haven't covered covered them for reasons of time, about the power to do all of these things, which is the duty in respect of adults for unaccompanied children. And that's clause 3, but we don't have time to touch on that. So as a general proposition, you'll see you could be removed to your own country, or a country issued you with a travel document, or where you embark for the UK, or where there's reason to believe you would be admitted, which is sort of like, if you like, the Rwanda provision, if you like. And so it has, and that reflects the existing machinery in paragraphs 8 to 10 of Schedule 2 to the 71 Act, that sort of formulation. But in practice, it's narrow. If you're a national of one of those countries in new 80AA, so the EU, EEA, or Albania, again, you may not be removed to the country of which you're a national or citizen, or a country that issued you with a travel document, if you make a protection claim or a human rights claim. And the Secretary of State considers there are exceptional circumstances which prevent your removal to that country. And again, we see that formulation about what exceptional circumstances are. It will include, so it's non-exhaustive, but you get the general idea of where the bar is being set. A derogation from the ECHR under Article 15, or where protection is derogable, or you're subject to equivalent to the disciplinary, your country is subject to the disciplinary measures in Article 7 of the Treaty on European Union. So that obviously applies only to member states. And if you are a national of one of those countries, so again, let's focus on Albania, you make a protection claim or a human rights claim, you may be removed to a third country, a country from which you embarked for the UK, or a country or territory to which there's reason to believe you would be admitted. Again, that formulation, but only if it's a state listed in Schedule 1. So this brings us on to our second list of states. We've dealt with new Section 80AA, which is the EU, EEA states, and Albania. And then we come on to Schedule 1, which is a longer list, includes all of those countries, and then some countries in South America and Africa and in Asia as well. So it's quite a complex regime, and of course you'll immediately be thinking, but the UK doesn't have any arrangements to remove anybody to third countries other than Rwanda. This is wishful thinking, and you'd be right to have all of those thoughts, but they are planning for no doubt, for a series of agreements, if only in their own minds, rather than in reality. But it has, and so we have this list in Schedule 1, which just deals with all of those countries. So the idea is those countries will welcome with open arms the removal of third country nationals to them, even though they have no previous connection with that third country. If you're not a national of one of those countries, the EU, the EEA, or Albania, you make a protection claim or a human rights claim, you may be removed to a third country, and you may not be removed to a country of which you're a national or citizen, or of which you've obtained a travel document, and you may be removed to a country in which you embark for the UK, or to which there's reason to believe you will be admitted, but only if it's listed in Schedule 1. So that's the formulation that exists for people who originate not from Albania effectively, but from other countries as well, but who are subject to this clause 2, satisfaction of the 4 conditions. That means that the duty to remove them is on the Secretary of State, and then she has to find a country to which there's reason to believe the person in question will be admitted. It has to be on the list though in Schedule 1. Rwanda is on the list, just for the avoidance of doubt. And you'll remember this from sort of clearly unfounded lists under the 2002 Act, that sometimes there's designations in relation to these duties. So it's not just that the country is specified, but it can be specified in respect of a particular part of the country, a particular territory, or in relation to people with particular characteristics. And so at the moment, Ghana, in respect of men, is specified. The idea is that that would be considered a safe third country of removal. If you're male, and in respect of men, then Ghana is safe for you. That's an actual example from the list. And again, we have, like we had with this list of people being added to Section 80AA for the purposes of the regime outside of the illegal migration bill, for the regime inside the illegal migration bill, for that long list of potential third countries under Schedule 1. The Secretary of State has the power by regulations to add a country or territory or part of it if in general there's no serious risk of persecution, and if in general it won't contravene human rights obligations. Designation may occur in respect of particular general characteristics such as sex, language, race, religion, and so on, or any other attribute or circumstance that the Secretary of State thinks appropriate. There's one for the imagination. The Secretary of State must have regard to all the circumstances in the country or territory. So again, it's judicial review paradise in a sense, because the question of what constitutes all the circumstances, and must have regard to information from any appropriate source. And then again, there's power by regulations to leave out a country, omit a country or territory. And statutory instruments, again, if you're adding a country, the procedural safeguard of the affirmative resolution procedure is required. If you're removing a country, there's a less onerous statutory instrument procedure for to go through. And once again, it's worth remembering these cases about adding and removing state designated safe third country lists, Jarman and Brown. I just put them on the slide additionally because we're now considering them for the purposes of the Schedule 1 list and not for the purposes of the Section 80 AA list. So that's inadmissibility under the regime. Two pockets. One, amending the regime for people who are not subject to the duty to remove under the Immigration Bill. Two, deploying the term for the purposes of consideration of removing people inside where the duty to remove does exist under the Illegal Migration Bill. Thanks very much.
Thank you very much, Adrian. And as we can see, there's a lot of food for thought there in relation to particularly where we are in the bill. There's so much going on. I just wondered, we have got some time for questions. We did start a couple of minutes late, but if anyone has got any questions, please do say so now. I don't think I've seen any on the in the Q&A as yet, or there have been some that have been answered on online. Does anyone have any questions? Oh yes, go on.
Sorry, I've got a practical question really on challenging inadmissibility.
Yes.
Just kind of about how helpful Strasbourg jurisprudence is in challenging inadmissibility decisions, thinking particularly about asylum seekers that may have travelled through Greece, and obviously the recent decisions relating to deficiencies in the process for asylum seekers there. How would you go about, if you were to cite said decisions, how would you go about doing that effectively?
I mean, do you want to?
I guess in general, I'd say they could be pretty relevant if they were strongly supportive, right? So if it suggested that conditions in a country were always sufficiently bad that there'd be a risk of Article 3 breach, then probably that's the kind of thing you could rely on to say that it would not have been reasonable to claim that. Definitely think it's worth including if there is anything. Though obviously if the claimant falls in a specific set of facts that case addresses is even better. I would think. So, I mean, that's why it'll be easier probably in general if the connection to a safe third country is to a country that's less safe. It'll be easier to argue that it wouldn't have been reasonable, right? So yeah, but you should definitely do it.
I mean, classically on those kinds of journey cases, you need to file evidence as to why you are unable to claim or what happened to you in the en route. And in Greece, you may well be talking about conditions. In Italy, you might be talking about access to the procedure. And so you will have, that is likely to be specific evidence that you would use on behalf of your client, as well as relying on generic conditions as in MSS, for example.
And also just to say, and I guess this is your question of like how you deploy it, but if in any of those cases there was evidence that what your client says happens frequently, then it would obviously support the sort of credibility of what they were saying, I think.
Absolutely. There's a couple of questions online. I'm just going to take the second one first, which is from Jessica Benton. Given the vagueness around disability and LGBTQ and identity as a ground for persecution under the Refugee Convention and under Secretary of State's considerations, would you say these groups are more at risk from these changes, especially considering disability law is relatively new in Rwanda and persecution against LGBT people has been reported there? And the first thing to say, I think, about Rwanda and LGBT, as I understand it, is that nobody whose asylum claim was based on that or had those characteristics was was subject to the Rwandan regime because the Secretary of State acknowledged in their own country of origin information that it wasn't safe for those groups, that group, if I can say. And so, which demonstrates the point that Adrian's been making about the government cherry picking certain characteristics and saying, well, this group, that group might not be, but that doesn't mean we can't send a group there. I don't know the situation in relation to disability law, but the same may well be the case.
They don't, I mean, actually, weirdly in their CPN, they don't actually accept that there is a risk to either of those groups. But my understanding is that, again, like for operational reasons, they didn't remove anybody who was LGBTI.
So operational reasons means we don't think we're going to win the judicial.
Yeah. So anybody who put in reps saying that was relevant, I think was taken out of it. But in their, and I think actually disabled people, I mean, I've never come across any cases where that was relevant. I can't say that there were none, but none of the ones that ended up in the divisional court had that as a relevant factor. So there's kind of this like shadow thing where they don't accept overtly that those are risk factors, but they, like Sonali says, don't really want that to kind of be exposed to scrutiny. So in practice, they don't seem to be pursuing removal against people with those.
So another question, which is, I may have misheard or misunderstood the part about whether the responsibility to consider asylum claim after 6 months period following an NOI, is this automatic?
With Alison.
Alison, are you able to answer that?
Yeah, sure. No, it's not automatic. So under the rules, you can, the rules provide that a claim can be admitted if it's been no longer realistic to expect removal in a reasonable time, and then the policy says that 6 months will kind of generally be the sort of time frame within which it should be possible to arrange removal, but then goes on to set out a whole series of caveats to that, circumstances where it might be less than 6 months and circumstances where it might be longer, including where there's ongoing litigation. So it's in the inadmissibility policy on third country cases that it's all set out in more detail.
Yes, I think I'll just also add that the 6 month period actually came from Dublin, which was well, as far as I can see, it was there in the Dublin policy and it just got transposed into this policy, and it remains there. So I think it's a bit of an arbitrary figure, but based on that history. There's another question, which is what place does Section 8 of the 2004 Act have with regards to coming from your country of origin illegally, with what we know from Professor Hathaway and from the cases of Ademi and Asfor, where there is an element of choice where they claim asylum. Adrian, do you want to answer that?
I mean, I think one of the things about the definition of coming directly, which we see in clause 2, is that what you have here essentially is an attempt to bake into primary legislation a definition which is different to that commonly understood in the Refugee Convention interpretation by courts that have given judgments about it, by the guidance of UNHCR, who of course have a statutory mandate for that. So if you look at clause 2, subsection 5 of the bill, if you can bear it, you'll see that coming directly include if you've passed through or stopped in another country where your life or liberty were not so threatened, so stopped. There's the definition. What happens if you're stopping for the night to sleep, for example, and then you're resuming your journey in the morning? Is that stopped? Would that take you outside of coming directly? So if you have to cross France in a day, is that the idea? I mean, and so what they're trying to do, of course, we have a dualist system, international law, very nice, but it's not part of our domestic law unless it's incorporated by Parliament, or unless we have a practice to the effect of giving effect to it. And here Parliament will have spoken. There will be the statutory meaning of coming directly, and the question is, and the intention is certainly that will displace any international law interpretation. Whether the extent to which it does so might be the matter for litigation, but that's the and we saw that technique not just in we don't just see it in the illegal migration bill. We saw the attempt to bake into primary legislation in the Nationality and Borders Act, Refugee Convention, successful attempt to bake it into primary legislation as well. So so this is like, if you like, a part 2 of that exercise of debauching the learning and the jurisprudence of the Refugee Convention and the guidance of the UNHCR by Parliament deciding that it knows more about the Refugee Convention and how it's to be interpreted than all of those people with expertise.
I would just add as well, Article 31, that definitely interpretation is one of the issues that the Court of Appeal are going to look at, and whether being sent to refugee because of your method of arrival constitutes a penalty will be live in that. Another question.
A question for Adrian. Earlier you said that the Home Office, maybe next year or in the near future, they might attempt to make some sort of agreements with other third countries, European countries. I understand how the Rwanda situation is going, how it's stuck and has got to go through a number of barriers. But in regards to that, what is the possibility of the United Kingdom negotiating something like that, particularly since we just had Brexit and our relations aren't the best?
No, they're not. I think third country removal agreements. I think the Home Office ambition at the moment, or the Foreign Office ambition, is to conclude them with countries outside of the European region. In the first instance, it's usually caught up with other. I mean, we sort of tend to, as lawyers, particularly working in protection claims, think it's all about the removal of asylum seekers. But if you look at the UK's relationship with Rwanda, there's a whole bunch of stuff going on in terms of the UK's international relations with countries in the region, of which this forms a part. And so sometimes the opportunity comes up, as it did with Rwanda, for the UK to have that agreement. Whether they're successful in making that part of their overall relationships with other countries remains to be seen. I wouldn't think that there's a likelihood of third country removal to countries that are member states of the European Union at the moment, because the competency for that arguably rests with the European Commission, and the Commission has no mandate to negotiate a third country removal agreement at the moment, because it hasn't been given that function by the European Council. The heads of state function in the EU have not given the Commission the mandate to do that. So I think it's very unlikely in the short term.
I mean, absolutely. I think it would undermine the sort of the European project as to why would they commit now an arrangement with the UK if it wasn't part of the exit agreement. So, and that is why we're in the situation we're in, without a doubt, that there was we wouldn't have had those the kind of crossings we have if they'd been part of the exit arrangement and a negotiation about returns. So I don't think I've got any other questions. Let me just check if there's any more other questions. Oh, there's another question here. I've got two more questions I've got. Thank you.
Okay. Hi. Yeah, I had a question about removal under the illegal migration bill and the relevance of being from a country listed under ATAA. Would that mean that you can be returned to your country of nationality, or is that not quite what it means?
It means that if you raise a protection claim, that you cannot be the idea is that you would be your claim is inadmissible. So therefore, sorry, let me just get the slide. It's very complicated. The idea is that your claim, you're not at risk in relation to that, and therefore you are in principle removable to that country. To the third country. Sorry, not to your own country. Sorry, yes. So the country of your nationality, the country you've not had your asylum claim or your protection claim processed, it's inadmissible. So therefore, they can't. The difficulty is that you can't say that person doesn't have the risk. You can't say that they're not at risk. Therefore, you have to propose a third country of removal.
Yeah, that's right. I hope that answers your question. I've got one other question on the screen, but I'm happy to take one more after that. If the inadmissibility scheme is implemented unamended, what do you think the knock-on effect will be for the immigration bar and legal aid sector with the drop in appeal rights, and how can it best adapt? One observation I would make at the beginning is the tribunal are already trying to adapt to that, what they anticipate, by recruiting lots more judges. The upper tribunal, thinking that the appeal rights are going to go from the first tier, and recognising that there may well be a lot more immigration judicial reviews in the upper tribunal. So that's one thing. So certainly adapting in that context means you'll be still making lots of representations, still be litigating. It's more likely to be in a judicial review than in an appeal. I'm sure the legal aid agency are well aware of that, and certainly they know what's coming. So that's the sort of broader picture. I don't know if I can say anything more than that. Best adapt is, and I was just thinking how much one has to keep on top of in this field. And if you go on holiday for a week, or if you happen to be out of contact even for a day, sometimes you miss major policy announcements or major changes. So the best thing we can do, I think, as a bar, and solicitors as a profession, is to make sure we share as much information as we can and share our learning. And the collaborative approach, which finally I think came out in the Rwanda appeal, was really, really important to any potential success. I'm not saying it will succeed, but if it does succeed, it will be because of a collaboration on all parts. I think, although we did start a couple of minutes late, unless there are any other questions, I'm going to draw the event to a close and thank everybody very much for coming. You've got one more question? Okay, I'll let you go.
So I understand that this Rwanda policy essentially started in 2022. Now we've come into 2023 and it's still within the courts. It's a bit of a big question, but when do you estimate that it will go to the furthest tribunal, to the highest court possible? When do you think it will come to a stage where the courts will no longer want to handle it and just hand it to Parliament?
It's a very difficult question to answer, but if judgment was given against us in the Court of Appeal by, say, the end of July, then we'd have to look to if there's an application to the Supreme Court, which there may well be, or would be, I would imagine. And the government did say that they would not resume removals to Rwanda, although they didn't say anything about any other country, until the conclusion of the domestic proceedings, so specifically excluding Strasbourg, and then read into that, or read across what Adrian's just been talking about in terms of interim remedies. This is heading potentially for I was about to say collision course with Strasbourg, a course with Strasbourg, an interaction with Strasbourg, and that will be then seen in the context of the domestic litigation that we have in place at the time that happens. I don't think it's probably not that fruitful to say anything more because there's a lot of speculation, but I think you have to be prepared for the fact that you may need to be making applications to Strasbourg, because that's where it may well end up before anything further happens.
Just to add to that, I mean, I think Swetha Braverman was asked again like 2 days ago about the economic impact of the 2023 bill, and she said again that she can't say because they don't know whether Rwanda will be possible, and they will need to wait until they see if it's legally viable, i.e. gets through the domestic courts. So they've said that repeatedly. So I think the position politically, at least, is that it's not going to go ahead until the UK Supreme Court, if it goes there.
Yeah, go. Yeah.
Just in answer to that question about the schedule, the states listed in Section 88, of course, you can be removed to a third country. That's fine. You cannot be removed to your own country if you make a human rights claim, and the Secretary of State considers that there are exceptional circumstances to prevent your removal to that country, and those exceptional circumstances include, but not limited to, where there's a derogation from a human rights protection in that country. So otherwise you could be removed. And of course, the thing about Albania is that there's an admission agreement. And so I think the idea is that they keep a long stop to say that she hasn't fettered her discretion. She could say there are exceptional circumstances which prevent your removal, but one can assume that in the ordinary course of events, they're not going to be considered to apply. And there is, of course, a relationship between the UK and Albania.
I think Alison wanted to come back. Was that the point you wanted to make, Alison? Yes. Okay.
Does that mean that unless there are exceptional circumstances, return an Albanian asylum seeker to Albania without substantively considering anything to do with their asylum claim?
Yeah.
Yes.
Cool.
Yes, and that is then the remedy would then be a Strasbourg application, and that's where
breach of the refugee.
and Article 3. So that means you would end up in Strasbourg, and ultimately that's where this is going, and I think on many levels. Anyway, plenty of food for thought, so to speak. I thank you very much for coming. I just wanted to remind you that it is Refugee Week, as I started out by saying, and it is important that we recognise these events. They do inform and educate us all. So And the next event we have is on the 21st, which is next Wednesday, online tickets available only. That's in relation to accommodating asylum seekers, barracks, barges and hotels. So that's depressing that sounds. And then on Thursday, the 29th, criminalising channel
Tomorrow, I
crossings.
think about it.
Oh, yes. That's tomorrow.
Yeah, next Thursday
Next Thursday is the 29th, yes, criminalising channel crossings, rescue penalties and refugee convention compliance. So if you can, catch up with those because you'll learn something quite definitely. I hope you've learned something this evening and we've shared important information. Thank you very much for coming. Thank you.